Morning.
Morning.
The record reflects we are back in session on the Merritt matters to continue to review the remaining motion for new trial and the motion to reduce the death verdict to life in prison without the possibility of parole, and then eventually sentencing. I apologize for the delay in getting started again this morning. There was a problem at the jail with the transportation of Mr. Merritt to court, and some problems with the elevators and getting Mr. Merritt up to court. And then Mr. Moline filed another motion this morning to disqualify the court from ruling on the remaining issues. And again, that was filed just a few minutes before we started, so it took me a little while to read that. So the only issue that the court can rule on at this point is, with regard to that motion to disqualify the court, is whether or not the motion is timely filed. Under CCP section 170.3 C1, the court does have the authority to strike such a motion if it is not timely filed. If it is timely filed, then the procedure is that the court must file a written statement in opposition or denying the allegations within 5 days, and then that goes to the Judicial Council, who would then appoint another judge to rule on the motion. So that would obviously take some time. The only, as I say, the only issue this court can rule on now is whether or not the motion to recuse or disqualify this court from the remaining motions is timely filed. And in that regard, CCP section 170.3 C1 and California Supreme Court case of People versus Scott at 15 Cal 4th 1188 state that the motion to disqualify a judge must be filed at the earliest practical opportunity once the grounds for the motion are discovered or known by counsel. Here, the primary allegations alleged to disqualify the court are the fact that the court allowed counsel to meet with the jurors in the jury room after the jurors had returned the final verdict in the penalty phase, and the court was also present for that. And then when the bailiff notified the court that the McStay family wished to come in to thank the jurors, the court allowed the McStay family to come in to thank the jurors. And then Mr. Moline complains about the atmosphere that existed during the time that the jurors and the McStay family and the court were present. So the issue is whether or not the motion at this point is timely. Clearly, it is not timely. That occurred 7 months ago. All of that was known to the defense. literally from the time it occurred, although Mr. Moline and Mr. McGee were not present. Defense investigators, Suzanne Serta-Haley and Mr. McGee's second or assistant counsel was also present, so they were certainly apprised of the whatever occurred at that point in time. Since then, as I say, 7 months have transpired, and during that 7-month period, Mr. Moline requested additional time to file motions for a new trial. At least one of the motions for continuance was granted. Subsequent motions were denied. Mr. Moline then, at the time of the hearing for the motions for new trial, filed motions for new trial. We spent an entire day discussing and ultimately ruling on some of those motions. And then apparently, what Mr. Moline also alleges, he was unhappy with how the court ruled on the motions and the manner in which the court ruled on the motions, and he alleges that as an additional grounds for disqualifying the court. Obviously, counsel's disagreement with the court's ruling on the motions, even the manner in which the court ruled on the motions, is not a grounds to disqualify the court. So those allegations can be stricken as not constituting grounds for disqualification. The fact that 7 months had elapsed from the time of the primary allegations that counsel now alleges as disqualification had elapsed, and that counsel in the interim requested continuances, actually filed motions for a new trial, and participated in a day-long hearing on motions for a new trial, clearly indicate that counsel did not file the motion to disqualify the court from these motions at the earliest practical opportunity once the counsel was aware of those events. So the court, based upon that, the court strikes the motion to disqualify on the grounds that it is not timely. Suffice it to say that if we were to reach the merits of the issue, the court would file the written statement denying the nature of the allegations and explaining in the court's view what in fact did and did not occur during the meeting in which the jurors, prosecution attorneys, and the McStay family were present. The defense counsel, of course, was invited to be present for that. I think the record indicates the court's comments at the time were if the jurors wished to speak with the attorneys would be available shortly, and that's when the attorneys had the opportunity to go back and talk with the jurors. But since the court is striking the motion for disqualification on the grounds of timeliness, this is not the appropriate time or manner to address the issues alleged in the motion. So the court will not do so at this time. Having stricken that motion for disqualification, court will continue to consider the motions that have been filed previously. As I indicated, there was an additional motion for a new trial that defense counsel made on the grounds of cumulative misconduct of the prosecutors during the trial. And there were, defense counsel provided a notebook with 6 exhibits, many of which were DVDs of, I guess, clips from various parts of the trial showing the prosecutors during particular moments of the trial. Court indicated that it would not view those or accept those exhibits, although they have been marked as exhibits. They are part of the record that any appellate court can review, but the court is not considering them for a number of reasons. First, if there were instances in these various clips that were not brought to the court's attention at the time, it would be inappropriate to make the motion at this time, since if it had been brought to the court's attention at the time, the court could address it. I understand that Mr. Mullane is of the opinion that the court did not do anything when, on the occasions he did bring it to the court's attention, and therefore, I'm sure he would argue that it was pointless to continue to do so. Nevertheless, if it's not brought to the court's attention, the issue is essentially waived and cannot be brought up as a grounds for new trial when it was never brought up during the course of the trial for the court to address. Of course, there were numerous instances where Mr. Mullane did, not just Mr. Mullane, where the defense team made objections and made allegations of prosecutorial misconduct, discovery violations, improper and misconduct in the courtroom, and the court, when it was brought up, the court did address those. Certainly, there were times where both sides, in the court's view, acted unprofessionally. There were times where both sides, decorum, professionalism, courtesy, or a lack thereof, were below the standards of what would be expected of counsel acting in a professional manner. There were instances, and the court commented on this during the course of the trial, there were instances where the court indicated it appeared that counsel on each side seemed to be more intent on attacking opposing counsel than they were in presenting their own case or in refuting the opponent's case. But the court, the times that issues or claims of misconduct were brought up, They were thoroughly discussed by the court, and the court found that there was not misconduct, although unprofessional conduct perhaps, but not misconduct. The remaining issue by defense counsel is that while each alleged incident in and of itself may not have been misconduct or rise to the level of such prejudice as to require a new trial, that the cumulative effect of the totality of all of the conduct of the prosecutors resulted in such prejudice that a new trial is necessary. As I indicated on Friday, in reviewing the transcripts and my notes with regard to the various motions for a new trial, the court also reviewed the transcripts of the areas where there were claims of misconduct, motions for mistrial, and I am satisfied after reviewing all of those that number one, there was no prosecutorial misconduct. Number two, there was no prejudice, even viewing the totality of all of the alleged instances of misconduct did not rise to the level of prejudice to the defendant. As I indicated during the trial and as I indicated on Friday, that it has been my experience, and certainly Mr. Moline is aware of a recent trial in which he participated, in which unprofessional conduct of, or what was alleged to be at least, unprofessional conduct similar to the conduct Mr. Moline is now alleging in this case was alleged in the other case, that was cited as one of the reasons by the jurors for voting not guilty in this other case. So it's been my experience that when counsel conduct themselves inappropriately, that does not aid them or their case, but is to their detriment in the jury's view. And I expressed that to counsel during the course of the trial. But in any event, court finds there was no misconduct, there was no prejudice to the defendant as a result of any of the complaint of conduct by counsel. And therefore the motion for a new trial on the grounds of prosecutorial misconduct and the cumulative effect of the totality of the prosecutor's conduct is also denied. With regard to the motions for new trial, Exhibit 7, which was all of the diagrams, maps, illustrations by the defense cell phone expert, are admitted into evidence as part of the evidence submitted on the motion for a new trial on the grounds of both on the grounds of insufficiency of the evidence and ineffective assistance of counsel. Exhibits 1 through 6, which are either clips from the trial or additional evidence which was explained as necessary to show the falsity of the prosecution evidence. Those have been marked as defense exhibits 1 through 6. They are not admitted into evidence at the hearing on the motions for a new trial, but they are part of the record in the case for review. The motions for new trial having been denied, this then would be the time to consider the motion to modify the verdict of death to the lesser verdict of life imprisonment without the possibility of parole. Mr. Moline, did you wish to be heard on that issue?
Thank you, Your Honor. As previously discussed, there was a waiver taken. Mr. Merritt had indicated he didn't want any mitigating evidence presented for that purpose. Our position is that Mr. Merritt didn't commit these crimes, so there's no plea of mitigation to lessen a sentence. In fact, if you look at the probation report, Mr. Merritt indicated...
Actually, I didn't review the probation report because the court can't consider that in the motion to reduce the penalty verdict. The court can only consider the evidence submitted at trial. You could argue if there's something either of evidence at trial or any inferences to be drawn from the evidence at trial, you can certainly argue that.
It would be the same arguments of insufficiency of the evidence, Your Honor, that we have previously made. There's no sense in making those all over again. The court has read our motion for new trial, has heard the arguments, is well aware of the facts that the defense stands by, and the court has made its position known in that regard. But we would still like the court to consider the insufficiency of the evidence, because at the end of the day, there is no evidence linking Mr. Merritt to these brutal murders. The fact remains the February 4th circumstances of events cannot be explained as Mr. Merritt as the perpetrator in any way, shape, or form. Whatever mental gymnastics one wants to undergo in their mind, it would exclude Mr. Merritt as the perpetrator if the theory that his truck was the truck leaving at 7:47 p.m. on the 4th. Taking that into account with the fact that you have QuickBook activity from 7:55 to 8:05 p.m. in the house. This wasn't remote QuickBook activity. This was activity testified to by prosecution witnesses and defense witnesses that happened in the house from 7:55 to 8:05. Coupled with the fact that you have the phone call from Joseph to Mr. Merritt that was witnessed by his wife Kathy and his daughter Taylor. She didn't witness the actual call, but Kathy Jarvis witnessed the actual Joseph McStay name come up on his phone with Mr. Merritt present. So that circumstance, those circumstances would not allow Mr. Merritt to be the perpetrator of these crimes under the prosecution theory. So how we got to this place, I don't know. There's no evidence linking Mr. Merritt. It's a lot of name calling in the trial, that he's greedy, he's a gambler, and that dominated, and it had an effect on an already receptive jury who, of course, who could blame them? They would want to give justice to the family who had waited so long. But if you look at the evidence, there's nothing there. You can talk about the cell tower evidence as a possible thing that the jury could look at, which we've addressed. We tried to address we believe the mistake of the call data records, which indicate Mr. Merritt could not have been in the 85th degree azimuth, but the court has heard our arguments on that on Friday. the DNA evidence that the court cited, again, you're talking about a trace contribution. Don Jones, the prosecution's own expert, indicated that would be consistent with transfer DNA. It would be consistent, even though there's no evidence of a handshake or anything like that at the meeting on February 4th. If there was contact, a handshake or what have you, that would be consistent with trace DNA being on the steering wheel of the Isuzu Trooper. It certainly would not be consistent with somebody driving the car to San Ysidro, because there would be more dominant force of DNA on the steering wheel and the controls. So actually the trace amount of DNA on the steering wheel was actually something that was exculpatory, because it showed that he could not have been the driver. And the list goes on. Whatever the prosecution said about whatever fact, and this is what we wanted to present in the motion for new trial, whatever they said about any given fact or any given circumstance was taken out of context. And when you look at what the prosecution did with the exculpatory evidence, they hired an expert, Dr. Lenny Rudin. They had this expert for multiple years on the issue of whether the truck was Mr. Merritt's truck. As we get into trial, we have a 402 hearing where Dr. Rudin realizes that there's a problem with the measurements. He expresses those problems to Mr. Imes and a series of emails on February 15th. Now, mind you, we're over a month into the trial. The defense knows nothing of this, but Dr. Rudin and Mr. Imes are having these email conversations where Dr. Rudin is expressing his doubt as to whether or not it's Mr. Merritt's truck, with all the Faro scans and with all the imagery that they were trying to use to show it was Mr. Merritt's truck. And based on the hard data, based on the measurements, Dr. Rudin then shares a series of emails and text messages with Mr. Imes saying basically, this is not Mr. Merritt's truck. Now, what does Mr. Imes do with that information? This is his expert at the time. What does he do? Nothing. He covers it up. He doesn't fulfill his duty in a death penalty case and tell the defense, hey, wait a minute, this is not, these measurements, we may have a problem with these measurements and I should disclose that to the defense. Instead, Mr. Imes keeps that information to himself and it represents to the court and to the defense that everything is A-OK.
I'm sorry, Your Honor, I have to object. That's a false misrepresentation of this court.
Let him finish his argument. You'll have a chance to respond.
He withholds that evidence. He has a text message that further and more specifically indicates why Dr. Rudin is expressing doubts about the measurements of Mr. Merritt's truck. Instead of disclosing that to the defense, he keeps it to himself, and we have to find out during a 402 hearing in the middle of trial that this exculpatory evidence exists. And in any other court that I can ever imagine, I've been doing this a long time now, in any other court, Mr. Imes would have been at the very least admonished in front of the jury. Jury instructions would have been given for withholding evidence, exculpatory evidence from the defense, and at worst, he should have been removed from the case, there should have been a mistrial, and he should have been charged with a crime. It's a crime for a prosecutor to do that. But nothing happened. The jury didn't know about it, the court did not allow us to ask and address those issues in front of the jury, so the jury didn't know what Mr. Imes did, the sneakiness of his actions, the misconduct that he engaged in there. The jury had no clue. And then, in closing, Mr. Imes argues that Dr. Rudin is some kind of freak and quack, and he's not to be trusted, that he was doing this testimony for his retirement. And he knows that they didn't charge him a penny. Dr. Rudin worked for free for them, and he worked for free when he contacted us. If not for Dr. Rudin contacting us and saying, hey, we got a problem here because I just watched Dr. Licio, Mr. Licio's testimony, and that guy is lying. And let me tell you the story. And that's how we found out about what Mr. Imes had done. And the court blocked that entire line of questioning so the jury could not hear it. We could have used, and by the way, we didn't know until, that didn't come out until April, well after Mr. Liscio had testified. So we couldn't even use that information to cross-examine Mr. Liscio at the time. Sure, we could have called him back, but it's better to cross-examine on those issues, and it would have been much better for the defense to be able to do that at the time. And then, during the time that the court indicates that there were multiple allegations of misconduct, on many of those occasions, Your Honor, Mr. Imes demanded a hearing. If the court recalls, Mr. Imes demanding a hearing as to the misconduct allegations. Well, when it came time for us requesting a hearing on his misconduct and withholding that information from the defense, the court didn't give us a hearing. Mr. Imes didn't want a hearing then, because you know what Mr. Imes did? He submitted a declaration to the court as his explanation for destroying the text message that he got from Dr. Rudin, and the court allowed that to occur without a hearing. So you can understand how we believe during the course of the trial.
I'm going to object. This isn't really relevant to reducing the verdict at all.
Go ahead.
This created the atmosphere that led to a jury that can find Mr. Merritt guilty. When you talk about greed, and when you talk about all the things, the nonsensical things they talk, how do you counteract something when they're just name calling? You can't do it. And that's the atmosphere that permeated the trial. But in terms of evidence, Your Honor, there's no evidence that Mr. Merritt did this. Not one shred of evidence. And it was the court's responsibility to say, wait a minute, guys, where's the evidence? Where is it? Before we're gonna determine, before we even go to whether the jury gets to decide or not, where is the evidence? The court had that opportunity at the 11:18, and it doesn't matter what the court's going to read in terms of the court's slant on the evidence. It really doesn't matter, because everything the court says about what Ms. Blake said or what Michael said, it doesn't matter, because they were impeached with earlier statements that were contradictory. So there's simply no evidence in this case. But the court, this is where we're at. I'm not sure how we got here, but we're here. And the court's going to do what the court's going to do. But in regards to reducing the sentence, if the court is going to go with the jury's finding in this case, what other sentence is there? The brutal killing of 2 toddlers and an entire family? There's only one verdict for that, Your Honor. It's just not Mr. Merritt who did it, but I don't see how the court can do any other, I don't see how the court can do anything other than what was been recommended by probation and what the prosecution has been asking for, because this type of a crime demands that type of punishment. It's just the wrong guy. And I'll leave it.
Mr.